Mr. Hasselback, do you swear or affirm under penalty of law that the testimony that you're about to give is the truth?
Yes, I do.
Thank you. Again, Mr. Hasselback, would you just kindly state your name, your title, and the agency you represent for the record?
Yes, sir. My name is George Lloyd Hasselback. I am currently the legal counsel for the Office of the Public Auditor, and I'm also the supervisor for the investigations unit.
Thank you. Mr. Hasselback, are you aware of why you are present today to testify?
Yes, sir, I am.
Okay. The articles that relate to today's hearing is Articles 8 and 16.
Yes, sir.
And just for the record, Articles 8 is a corruption charge relating to the sole source contract for IPS, sole source IPS contract for the management of the ARRA grants.
Yes, sir.
Mr. Hasselback, has your office conducted an investigation of the sole source contract?
Yes, sir, and it may be helpful to continue in the manner in which we've done in the past. I can give the panel a brief summary of the events that our office was involved in.
That would be helpful.
Yes, sir. The Office of the Public Auditor often receives complaints. We have a hotline. We also have an online method by which people can leave complaints and suggestions through our website. We received at least 4 requests for investigation between October 20th and October 22nd of 2010 through our website. There may have been more. The only ones I have record of are those 4. They all generally said the same thing. They generally asked our office to look into the sole source contract that is the subject of today's discussion with the panel. We conducted an investigation. This was a joint investigation with the U.S. Department of Interior Office of the Inspector General. They are one of the agencies, the Department of Interior is one of the agencies that provides the CNMI with federal funding in a variety of different methods. And the Office of the Inspector General, in case the panel doesn't know, the Office of the Inspector General is the office within the Department of Interior that handles their investigations. They have criminal investigators similar to what we would think of as a government agent. They are similarly empowered, like FBI agents, to conduct investigations. That investigation was conducted primarily by a Department of Interior Inspector General Special Agent. The Office of the Public Auditor provided support, so it was a joint investigation. I believe that the panel has been provided not only a copy of the complaint forms from our website, and was also provided a report of investigation from that Department of Interior OIG Special Agent. His name is David House. And pursuant to that investigation and the report that was generated, I determined that there were additional criminal charges warranted against former Attorney General Edward Buckingham because of his involvement in this particular set of circumstances. Now, for the panel's information, the 2 counts that are contained in both the original information and the amended information that relate to the subject of today's hearing would be count 4 and count 5. Count 4 is a failure to produce documents or information. At one point during our investigation, post-investigation wrap-up, I guess you could say, we requested further information from the Office of the Attorney General, and Mr. Buckingham responded that that information would not be forthcoming. He gave several reasons why, and we disagreed with him that those were legitimate reasons to refuse to provide information to the Office of the Public Auditor. Our CNMI statutes require and obligate governmental agencies and governmental employees to cooperate fully with OPA investigations. Mr. Buckingham declined cooperation and again offered various reasons why, and I made the determination that none of those reasons were sufficient to completely refuse to cooperate. So that would explain count 4. And I'm sure the panel's read that document. I'm not going to bore you with reading it again. The alleged facts are contained therein. Additionally, count 5, misconduct in public office. That may require a bit more of explanation. Misconduct in public office in the CNMI comes in 2 flavors. The first is when a public official commits an illegal act under color of their office. And the second flavor of misconduct in public office is when a public official willfully refuses or willfully fails to do what they're supposed to do, to fulfill one of their duties. And it is that second type of misconduct in public office with which Mr. Buckingham is charged in count 5. Let me explain it a little bit further. I allege that, that Mr. Buckingham had a duty to review the sole source contract for 2 things. For form, which just means that it's in the right form. And second, for legal sufficiency. Second, for legal capacity. What that means is that the review should see if the Commonwealth can or has the capacity to sign that contract. Since we concluded that the contract violated multiple sections of the CNMI Ethics Code, we concluded that the Commonwealth did not have the capacity to sign that contract. Because generally speaking, the Commonwealth can only sign contracts that comply with its own laws and its own regulatory rules. Since this contract did not, comply with those laws and those regulatory rules, the Commonwealth lacked any capacity to sign this contract. Mr. Buckingham, to my belief, knew or should have known that this contract that the Commonwealth did not have the capacity to sign this contract, and yet he signed off on the contract anyway, asserting that the Commonwealth did have the capacity to sign the contract. So the willful failure was his willful failure to refuse to sign this contract. His willful failure was his willful failure to point out that the Commonwealth lacked the capacity to sign this contract. It takes a couple steps to get there. My apologies if my explanation has been a bit convoluted. It's just that's how the several laws interface with regard to these criminal charges. And if the panel hasn't already done so, I would encourage the members to carefully read Agent House's report of investigation. It is a very good outline of the various CNMI ethics rules and ethics laws that we believe this contract violated. So, given that, I filed the information that you've all seen, which contained those 2 criminal charges, and that was part of the document that was attempted to be served upon Mr. Buckingham before he left the Commonwealth.
Thank you, do you know, can you tell this panel what the status is of the information that you submitted?
Well, sir, I filed the information, and as the panel knows, I filed an amended information. And while we're on that subject, I submitted a supplement to our initial document disclosure that should have contained that amended information. I hope you all do have copies of that. That information was filed. There were some motions filed by Mr. Buckingham's counsel. And then I recently asked the court to declare Mr. Buckingham a fugitive from justice and to decline to hear any further motions from him until he returned to the Commonwealth and cured his fugitive status. The court agreed and has declared Mr. Buckingham a fugitive. The court furthermore recently filed another order, or issued another order, pardon me, reiterating that it will not entertain any further motions from Mr. Buckingham until he comes back to the Commonwealth to cure his fugitive status. So that's where it lies. I mean, I wish I had a more satisfactory answer, but it's kind of in limbo right now. Everything's put on hold. The court is not going to spend any more resources entertaining motions from the defendant until he comes back. To my knowledge, he has not returned yet, so we're kind of on hold. And that's the status of the information. We are at the very, very earliest stages of a criminal proceeding. There actually has not even been an initial appearance yet, which is typically the very first thing that happens, but that hasn't occurred yet. So we are very early on in that stage.
Mr. Hasselback, in reading the report filed by the Inspector General, their disposition of the joint investigation conducted by your office and their office, or rather, based on the joint investigation, it was decided by the U.S. Attorney's Office for the District of Guam and the CNMI that they are going to decline prosecution of this investigation due to the lack of evidence that the contract violated any federal statute. That was the District Attorney's disposition, I guess.
Yes, sir.
The reason they did conduct an investigation, I'm assuming, is because the contract involved the use of federal funds.
That's correct, sir.
Okay. But in their investigation, they did not conclude that there was a violation of federal law.
That's correct, sir.
Your agency, again, I presume, was investigating this matter to determine if CNMI laws were violated.
That is correct, sir.
I think both agencies, both reports reflect a violation of CNMI law and the ethics code.
That is correct, sir, yes. If I may explain and elaborate a little bit, quite often in these type of joint investigations, in the beginning, the reason we conduct an investigation, the reason any investigation is conducted, is that in the beginning of a situation, the people conducting the investigation don't know what they're going to find. Sometimes they find violations of the law, sometimes they don't. In this instance, the investigation was jointly performed, as you pointed out, by local and federal authorities. Now, at the conclusion of the investigation, the determination was made by the federal authorities not to prosecute because the federal authorities did not perceive sufficient evidence to support charges of violations of federal law. Now, that doesn't mean, and that doesn't really have any effect upon whether or not there were violations of local laws that were found. Now, again, the Special Agent House's report is very specific and talks about the local CNMI laws that he believed were violated. our office took that information, reviewed it, and agreed that local laws were violated. Now, since we have two parallel judicial systems, the federal system determined that there were going to be no criminal charges. On the other hand, the local system, through the Office of the Public Auditor, determined that criminal charges were justified.
To further clarify that, I think initially, after your investigation was conducted, and I think initially you presented your findings to the Attorney General first, or rather to the Governor first. Is that correct?
Well, sir, there were some post-investigation exchanges of correspondence. We sent some letters over to both the Governor and the Attorney General, asking for further information, asking for clarification, telling them that we had conducted an investigation and were reaching the end stages of it, and that is the point at which the Attorney General made the determination that they were not going to provide any further information and not going to further cooperate because they questioned the validity of our investigation. Now, again, I didn't, I disagreed that any of those criticisms of the validity of our investigation justified a blanket refusal to cooperate. So they said, we don't wish to cooperate, and we acknowledge that.
Was there any recommendation by your office as to what the Governor can do to remedy the violations?
We hadn't gotten to that point yet, sir. The point at which this stopped was the point at which we were saying to the administration, we have conducted an investigation, we are concluding the investigation, we would like to, if you would like to respond or provide us any further information, we would accept it before making a final determination. And sir, that's when we got the response, again, a joint response from the Governor and the Attorney General, questioning the validity of the investigation and refusing to provide anything further. So that was the end of the road for us. To be specific, the criticisms of the investigation were many, but basically boiled down to a criticism that our office, specifically Mr. Pai, was biased to the point where the investigation was invalidated. There was also a criticism of one of our investigators, Mr. Juan Santos, that his participation in the investigation was such that, and he was so biased that his participation in the investigation invalidated the whole thing, and kind of along in that theme. So there was just a blanket refusal to cooperate, and basically we took them at their word that they would not cooperate any further and continued forward. And the final determination we made was that criminal charges against the Attorney General for his participation in this were justified.
I have no questions about the violations of CNMI procurement laws and regulations, and there are several. One is employee conflict of interest. One is restrictions on employment of present and former employees. There is 1 CMC 8544, negotiating for non-governmental employment. There's 1 CMC 8531, the use of office staff or employees of public office. And I won't even go into the details. But I think both your report and the IG report come to the same conclusions, that these statutes and these regulations were violated. Further, if the regulations or the terms and conditions of the contract violate these regulations and statutes, there is a controlling regulation that states this contract is null and void if either the procurement processes or the contract execution fails to comply with the CNMI procurement regulations. The contract is for 18 months. The contract is executed. The contract was found to be in violation of CNMI law and regulations, procurement regulations. I'm just curious to know why wasn't the contract nullified in accordance with law?
Well, sir, again, we have taken this step by step. The contract has been, as you said, completed. There was a renewal provision. My understanding is that it was not renewed. The governmental body that, thank you, pardon me, sir. The governmental body that is supposed to seek to recover expended funds on behalf of the Commonwealth through civil action is the Office of the Attorney General. I don't think I need to point out to the panel the problem with that. Here we have the Office of the Attorney General supporting this contract, or at least the last communication that I've received from them supported this contract. So it is highly unlikely that there will ever, in my mind, it is highly unlikely that there will be a civil action to recover these monies, because the body that is supposed to do that sees no issue with the contract, or says that they believe the contract is valid. So that is it's a function of the way the statutes are set up, sir. I don't have a better answer for you. There's nothing, from my perspective, that I cannot initiate a civil suit on behalf of the Commonwealth. I've looked at the statutes. I don't believe my office has the ability to do that. We can make recommendations to the Office of the Attorney General. We have been considering what to do with the contract and the monies expended. I don't believe we've made any formal recommendation at this point. However, I think the panel can understand why we hadn't when Mr. Buckingham was the Attorney General, because, frankly, to have done so, in my mind, would have been futile, considering his position on the contract all along.
Based on your investigation, Mr. Hasselback, what was the governor's role in the preparation, negotiation, and eventual execution of the contract?
Well, sir, as reflected in Special Agent House's report, he spoke with not only Mr. ARRA, but he spoke with the governor and the Attorney General. I could read the report for you, but it says at several instances that the terms of the, I'm sorry, perhaps not the specific terms, but the parameters of the contract were discussed the transition of Mr. ARRA from governmental employment to non-governmental employment, and contracting was discussed. You'll see there's some confusion amongst the testimony. Oh, I'm sorry, the statements of these individuals. Page 5, ARRA referring to Mr. ARRA and Fidel referring to the governor. Dispute who first brought up the idea of private contract to manage CNMI ARRA's projects. Both agree, however, that they developed the IPS contract while ARRA was in office, and ARRA said that he and Fidel had continuous conversations about the contract before he left office. And there are statements to that effect peppered throughout the report.
Yeah, if I may read parts of the report.
Please.
It says in August 2010, ARRA informed Fidel of his intent to leave government. ARRA and Fidel discussed privatizing ARRA's duties of managing CNMI's ARRA projects and funds. This is in August, and I believe Mr. ARRA didn't resign until October 8th. So prior to his resignation, there seems to be, according to this report, a discussion about Mr. ARRA intending to leave government, and discussion about Mr. ARRA potentially as a private individual managing CNMI ARRA grants. It says, during ARRA's final month in office, at Fidel's direction, ARRA prepared the service contract for the management of ARRA funds for award. And you know, according to this report, Mr. ARRA prepared the service contract, his contract, at the governor's direction. It goes on stating when Mr. ARRA resigned, which was October 8th. 2 days later, on October 12th, a $392,000 service contract was approved for the not yet formed IPS, meaning a contract was approved for $392,000 for a company that had not even been formed yet to manage the ARRA grants. The contract was officially awarded on October 13, 2010. And on October 14, that's when IPS obtained their business license. What's interesting though is how it was justified as a sole source contract. It says here, based on Fidel, so this is, the report references the governor's justification. It was the governor that justified it so that it can be awarded as a sole source contract. And further, based on another justification from Fidel, from the governor again, the CNMI advanced IPS $78,000, $78,418. And this contract was funded with administrative funds from ARRA awards. So, you know, these are just some of the facts, or some of the, rather the events that are in the report. There was the findings of the Inspector General report. It goes on further with regard to Mr. Buckingham himself, that Mr. Buckingham, the Attorney General, acknowledged that ethics concerns existed. So he did not dispute that ethics concerns existed and that Mr. Anda had a conflict of interest. He thought, however, that the need for the contract outweighed ethics concerns. So that, I think, was the justification that the Attorney General gave to justify the sole source award. Is that consistent with your report?
Yes, sir, it's consistent. I would like to be a little more specific about the Attorney General's justification, well, the justification for the sole source award, which was supported by the Attorney General. That justification can be boiled down to the statement that they were afraid, the Attorney General said he was afraid that if this contract was not executed with all due haste, the CNMI would lose its ARRA funding. Now, that sounds at face value very reasonable and very scary. However, I would like to draw the panel's attention to the last, well, not the next to the last section of Agent House's report, where Agent House actually went out and contacted the ARRA awarding agencies, the agencies that give the ARRA funds. Now, Mr. Buckingham said, well, if we don't do this right now, we're going to lose all of our money. And Special Agent House asked Mr. Buckingham if he contacted any of the agencies to confirm this, to see how reasonable a fear that was. Mr. Buckingham said that he hadn't. Mr. House asked if he had any support or justification for that fear other than what he'd already provided. Mr. Buckingham said he hadn't. If you look at the section entitled Response from ARRA Awarding Agencies, you'll find that simply contacting these agencies, which doesn't take a whole lot of time or effort, demonstrated that simply having one late quarterly filing would not have put any of the ARRA funds in jeopardy. I'll read a sampling here. Housing and Urban Development said said that their policy is to provide warning letters after the first 2 missed or late reports. Continues to work with recipients even after a 3rd failure to report. EPA, one of the other awarding agencies, said it was unlikely to pull funding from a recipient after a single late or missing report if circumstances prevented them from meeting these deadlines. EPA likely would attempt to address the issues and try to accommodate any specific needs. Department of Agriculture Emergency Food Assistance Program. His office had never had any instances of late reporting, but the CNMI wasn't required to quarterly report to them. Same with the Department of Education. Would not have pulled back funding from the CNMI for late reporting. U.S. Department of Health and Human Services said it would only freeze funding after the 2nd offense. So Agent House was able to reach out to these agencies and confirmed with them that this seemingly reasonable and very scary fear of losing ARRA money wasn't justified. Now, a person or an attorney who is reviewing an almost $400,000 sole source contract has a duty to conduct a little more due diligence other than just, oh gosh, we're afraid. It's okay to be afraid of losing money, but you have a duty to conduct some inquiry into how reasonable your fears are, especially when you're basing the award of an almost $400,000 sole source contract based upon those fears. In this instance, according to the interviews Agent House conducted, there was no due diligence performed. None of the agencies were contacted. None of the agencies were asked. That fear was merely transmitted onto paper and became the sole justification for that sole source contract. And I'd like to add something else. There is an important CNMI law that is not contained in Agent House's otherwise thorough analysis here, and that laws are CNMI Ethics Act conflict of interest law, which prohibits a governmental agency or the representative of a governmental agency. I'll boil it down, I'll remove some of the legalese, but basically what it says is that you can't award a contract or make a decision if you have a close personal relationship with someone who is going to benefit substantially from that decision. Here we have the final signatory authority on this contract is the governor of the CNMI. The person, one of the persons who stood and did receive a significant financial benefit from this was Mr. ARRA. During Agent House's interviews of the governor, it was revealed that the governor perceived Mr. ARRA as something of a son to him, a very close personal relationship. Our laws don't permit a governmental representative to sign off on a contract with someone with whom they have a close personal relationship with. And I'm sure you can all understand why. Now, the solution to that normally is to recuse oneself from the decision-making process and have somebody else do it. That's what normally happens. It doesn't paralyze government to implement this rule. I know some of you have all been public servants and worked in various government agencies prior to your position here, and you know that if your agency can deal with vendors that are closely related to you or that you have a business relationship with, you just can't be the person signing off on it. You have to step aside and let somebody else do it. And that wasn't the instance here. Here we have a substantial contract being finally determined by someone with a close personal relationship with one of the primaries of the business that is going to be getting the contract. I wanted to include that because that's something that wasn't included in Agent House's report. And again, this is something that further rendered that contract violative of CNMI law and further eliminated any capacity that the CNMI had to enter into it. The CNMI simply cannot enter into contracts that violate its own laws. It lacks the capacity to do so.
Thank you, Mr. Hasselback. Do any of the members have any questions? Representative Guerrero.
Good morning, Mr. Hasselback.
Good morning, sir.
How are you?
I'm doing well, thanks.
Good, good. I understand the contract and the investigation and whatnot, but did I hear you say that you didn't make a recommendation to?
Well, sir, the process under CNMI law, when we investigate anyone for an ethical violation, which is essentially what we were asked to do, among other things. But the primary thrust of our investigation was to see if CNMI ethics laws were violated. What we're required by law to do prior to the conclusion of our investigation is we're required to send a letter to the, I hate to use this term, but we're required to send a letter to the target of the investigation. So we'll use that hypothetical Mr. Smith again. And again, my apologies to anybody actually named Mr. Smith. If Mr. Smith is suspected of violating the CNMI Ethics Act, and we investigate Mr. Smith, before we conclude our investigation, we're required to send Mr. Smith a letter or some communication saying, okay, Mr. Smith, we're investigating you for violations of the CNMI Ethics Act for X, Y, and Z. We would like to conclude our investigation. Prior to concluding that investigation, do you have any documents you would like to provide to us? Do you have any witnesses you would like to direct us to an interview? Now, we have to do that, otherwise we can't conclude our investigations. So, in this instance, we did that. And that was the letters I was discussing with the chairman earlier. We sent letters over to the governor and to Attorney General Buckingham, and we said we are concluding our investigations. We provided them with the reports and some of the information that we'd had already. And we said, is there anything you would like to add? Would you like to add any further documentation? Would you like to have us interview any other witnesses? The response that we received was basically, we do not believe this investigation to be valid. We do not wish to participate in it because we do not believe it to be valid. We have nothing further to say. And that's where it ended. We didn't reach the point at which we were going to make recommendations because the communication was cut off. Now, had there been a provision of documents or some cooperation at that point, things may have gone differently. We may have tendered recommendations to the governor instead of pursuing criminal charges against the Attorney General. But we didn't reach that point.
Okay, thank you.
You're welcome.
Representative De La Cruz raised up his hand, but he just stepped out. Do any of the other members have a question for Mr. Hasselback? While we wait for Mr. De La Cruz. If not, I have again, going back to the Inspector General report, on page 4, on the last paragraph, it talks about the sole source justification. And it states further, the sole source justification memorandum from FITIO, from the governor, to the Director of Procurement and Supply, Herman Sablon, on October 6, 2010, acknowledges ADDA's advantage. It reads, Mr. ADDA has extensive historical and current knowledge, as well as non-public information of all ARRA funds. His clear advantages with the intricacies of the ARRA funds creates a distinct advantage should the CNMI government bid out the service according to procurement regulations. I just wanted to ask you, what is your opinion of this sole source justification?
Well, sir, like I said...
professional opinion, not just your personal opinion.
I'm not allowed the luxury of personal opinions anymore, sir. As I said earlier, if the sole justification, if the only justification provided for a sole source contract amounting to almost $400,000 of public funds is that one is afraid that not executing that contract at that particular time would result in losing millions of dollars of public funds. It is in essence a cost-benefit analysis. We either do this right now or we lose millions of dollars. In order for that cost-benefit analysis to have any validity, in my opinion, one would have to look at the likelihood of the loss of those millions of dollars of public money. One would have to weigh, in any cost-benefit analysis, you weigh the cost against the likelihood of an event occurring. That's why we get insurance for certain things. You know, the cost of insurance for your car is not too bad, depending on who you go with. and the likelihood that you might be in a car accident, everybody's in one eventually, almost, right? So you do a cost-benefit analysis. You look at the likelihood of the event occurring. In this instance, the cost, the potential pitfall, was the loss of millions of dollars of public funding, which is a pretty heavy cost. You worry about that. But there was no analysis of the likelihood of the event occurring. There were statements made by the former Attorney General that there were no phone calls made, there was no contact made with any of the awarding agencies to determine how likely it was that money could be lost. So in my opinion, that justification is insufficient. And as you pointed out, there was an admission that Mr. Atta was, for lack of a better term, an insider. What that means is, we've all heard the term insider trading. Okay, it's an analogy. It doesn't really have to do specifically with this situation, but the term kind of works. Insiders are people that have information that the rest of us don't. Now, the way the CNMI procurement regulations and procurement laws are set up is they disfavor insiders. People are not allowed to use non-public information to their advantage in the bidding process. That's admitted here. But there was no bidding process, so that really never came up.
Thank you, Mr. Hasselback. Representative De La Cruz, did you have a question?
Thank you, Mr. Chairman. And good morning, Mr. Hasselback.
Good morning, sir.
I like to think of this as another case of the fox guarding the hen house. I don't know what you think, but it appears that the report is one consistent with the ethics violations of the CNMI law. And understandably so, the investigative report submitted by the Office of Inspector General was correct in that federal laws were not found to be broken. They did find evidence to suggest that the IPS contract did violate CNMI ethics rules. It's interesting because during the time of Mr. Atta's employment with the CNMI government, he had discussed the possibility of the contract with the Lieutenant Governor. He even went as far as authoring a letter to OPA. Interestingly enough, the letter was signed by the governor. A letter coming from a prospective contractor, if you will, who is still in government, asking the public auditor for their opinions, but yet had that letter that he authored signed by this governor. The management contract was never advertised. One thing I do give credit to the governor, though, is that he stated in one of the reports here is that Mr. Atta had a very clear advantage in that he was very knowledgeable and he knew of the intricacies and that should the CNMI government bid out the services. So he was actually thinking, he had the thoughts of if this contract was to be bidded out. Although he knew quite well from his statements that Mr. ARRA had that advantage. He spoke of a bidding out of the contract, but yet, as you stated, this was an insider situation. It's very interesting that, as you mentioned earlier, this contract was done in haste. According to the report, if the CNMI government or the Attorney General's office took the time to contact these federal agencies that would award ARRA funding, such as HUD, such as EPA, such as the Department of Education, the federal government, he or the Attorney General's office would have found that there was still time to do an RFP, to bid out this management contract. But it appears that negotiations and discussions were already happening during the tenure, his employment of Mr. ARRA with the CNMI government. It's very interesting. I believe that it's a pretty straightforward report coming from the U.S. government jointly with your office. I find it also interesting that the Director of Procurement and Supply simply relied on the Attorney General's opinion rather than his own review of the document. It's very, very surprising to find that our own agencies of government would try to circumvent our own ethics laws. I'm sure that there are other people out there, other companies that would have, if given the chance, bid it on this ARRA management contract. But they were not given that opportunity. And that is the sad part of our government. I will yield for now, Mr. Chairman.
Chairman, if there is one thing that you brought up, sir, that I would like to elaborate on just a little bit. There was a letter. It is mentioned in, as you pointed out on page 4 of Agent House's report. ADA authored a letter regarding requesting an opinion to the public auditor prior to the award of the contract. See attachment 3. Fitial signed the letter. When I was asked the question earlier as to whether or not we had provided an opinion or a recommendation to Governor Fitial, and I mentioned that letter from both the Governor and the Attorney General that criticized our further investigation, one of the other criticisms was a claim by the Attorney General that an ethics opinion had been requested by the Office of the Public Auditor. and that the Office of the Public Auditor had said, okay, no ethics problems at all. I'd like to be very specific. We were not asked to provide correspondence to the panel. I can, if you wish, provide this. First of all, the request letter that is mentioned regarding an opinion requested only an opinion regarding the sufficiency of the sole source justification. In other words, it was asking for an opinion specifically regarding whether or not this contract complied with procurement laws. In fact, the word ethics never appears anywhere in that letter of request. So to claim that that is a request for an ethics opinion is a stretch. Secondly, the letter that we sent back after that request, it said a few things in the first paragraph, but then the second paragraph says, we are not, I'm paraphrasing because I don't have it in front of me, but it says, we are not providing you an opinion at this time. Because OPA is the public auditor, is the review body of procurement decisions. So we don't pre-review things. We wait for the process to take place. So, just to sum up what I said, the Attorney General, the former Attorney General, claimed that our investigation was invalid for a number of reasons, one of which was he claimed that we were asked for an ethics opinion, provided one, and they relied upon it. We were never asked for an ethics opinion. We were asked for an opinion solely upon the justification of the sole source nature of the contract. The word ethics never appeared in that request, and the letter that we sent back said, we're not giving you an opinion. So there is no reasonable way to interpret that as OPA saying the ethics of this contract are fine. There is no reasonable way for anybody looking at that to think that OPA cleared that contract for ethical concerns.
Thank you, Mr. Hasselback. Chair, at this point, I would like to ask that the committee be furnished with the correspondence, as Mr. Hasselback has offered.
I'll be happy to get that request letter. Just to be clear, sir, this is the request letter that Agent House.
Yes, we understand, Mr. Hasselback.
I'll get that, and I will give the response from our office to you.
Yes, thank you.
Any other members? You good? Representative Sablon?
Actually, I was going to address the particular